it's time to continue and talk a little bit about what kind of responsibilities that an ISP have. And here we have from the University of Stockholm, Daniel Westman. Welcome.
Good afternoon, everyone. So I'm Daniel Westman. I'm a lawyer. I'm working as a researcher and a teacher at the Stockholm University, and I'm also a consultant in IT law-related issues, and currently an expert on a couple of government committees working with different type of IT legal issues. For example, now the data protection regulation, looking into how to implement that in Sweden and so on. I've been asked here today to talk a little bit about some legal issues that hopefully are interesting for you, and we decided that I should talk a little bit about ISP liability. It's a classic topic, of course. Many of you have your personal view, I expect, and I have discussed these issues with a couple of you earlier, so I know that the interest in the technical community is big for these kind of issues. But I want to approach it from a legal perspective, and I also it's a classic topic, but there has been some new developments that could be interesting. I will talk a little bit about a case from the European Court of Justice. It's the highest court in the European Union, interpreting the legal acts in European law, and that is the copyright legislation, but also legislation on the e-commerce directive where there are provisions concerning the liability for intermediary service providers. So I will look a little bit into that. Can I see my own picture somewhere? No, okay, I have to turn my back on some basic starting points then. What about intermediary liability? How do you create the liability for intermediary service providers within the law? Usually it's done by saying that companies providing or individuals providing services of different kinds is aiding and abetting an infringement in some way or a crime by providing this service. And in most countries we have a very wide definition on how to what is aiding and abetting an infringement. So usually it also fits in on intermediary service providers of different kinds. And of course we can talk of different types of service provider, and of course there should be different liability standards. When you talk about mere conduit or providers of internet access or DNS service or something like that, of course that is a very technical contribution that is very far from the actual crime, so it's less liability in that situation, of course. But when you talk about service providers that hosts content for that is illegal in some way, of course there is a greater liability. So there are different types of service providers and different types of liability. And then you can ask yourself why, and many of you probably ask that, why should there be why are we focusing on liability for service providers? Why in the first place? And of course the easiest argument is this is an effective way to uphold the law. As you all know how the internet works, it's sometimes very hard. It can be mass infringement, mass crimes, but it could be very costly to go after every individual user. You have the anonymity problem, of course, that it's not even possible many times to find the individual infringer, the individual person who commits a crime. So easy way, a bottleneck function is the service provider, and it's easy to go after that. So from a effective point of view, and then you have and of course, there is as a starting point, it should be easy to uphold the law, of course. Then we have different laws and we have different opinions on these laws. If you talk about copyright, for example, there are different views on is the copyright legislation in itself acceptable, and then people find it's not, maybe it's not that good. If you don't like the copyright legislation as such, then you don't want it to be enforced by going after the ISPs, for example. But if you look at other crimes, for example, that people tend to be more in line with the general opinion on what should be a crime, then maybe you have a different opinion on how to enforce that kind of legislation. But of course, for me as a lawyer, there are great concerns with ISP liability, and that is also a knowledge that has been more accepted also in the legal community. There have been people in the technical community for many years arguing against ISP liability and saying that this is a problem. You cannot do this in that great extent as we have done. But there is greater awareness also in the legal community that this is also in conflict with fundamental rights if it's done the wrong way, if you're going too far into ISP liability. We have, of course, and I say conflict with other fundamental rights, because there could be a fundamental right to uphold the law also. For example, copyright is looked upon as a protection for property, seen as a fundamental right in the European Union, for example. So protecting copyright is a fundamental right. But then you have other fundamental rights. You have freedom of speech, of course. Every time you go after an intermediary in some way, if you ask someone to block or filter content, that is of course a limitation of freedom of speech. Also, holding someone responsible afterwards for what someone else has done will affect freedom of speech, because they will be more reluctant to host that kind of content or distribute that kind of content. So they're more, they have this, they are more careful what they accept and so on, and that is also a limitation of freedom of speech, of course. We have the privacy data protection concerns. Some of the, when you go after intermediaries, if you ask them, for example, to filter content, there are a couple of cases where, which I come back to later on, where there have been demands that an ISP should be obliged to install a filtering software looking for copyright protecting files passing through their network. That is, of course, going into individual traffic, and that is of course an invasion of privacy. You cannot discuss is it accepted, but it's an invasion of privacy or data protection. And also, as the European Court of Justice has said in their cases, there is also could be a conflict also with the freedom to conduct business. There is also a fundamental right, according to EU legislation, to if you have too far-reaching obligations for an ISP to do something, this is a limitation of their right to conduct business. If it costs too much, if it's too burdensome, and so on. And of course, there can also be a question of, often in this ISP liability situation, it raises question on the rule of law and security of law, because there is often the parties in a case, for example, where someone want for example, a blocking injunction issued against an ISP. The parties of that kind of court case is the right holder on one side and the ISP on the other side. But the real people that is most concerned about this is the people that make content available on the net and people that want to get access to content available on the net. But they are not parties in this in this case. So who take care of their interests and so on. So you have also this rule of law problems in ISP when it comes to ISP liability. Important distinction to make when you talk about ISP liability, and it's often missed, maybe more often when non-lawyers speak about ISP liability, is what do you really mean by liability? Are you talking about the full scope of obligations for ISPs to do something about criminal activity online, or are you just talking about legal or penal liability for what someone has already done? In the more narrower case, because as we will see, the liability in that sense, penal liability, claim for damages for what the users are using their connection for example, it's very limited. We have these safe harbor provisions that gives ISPs a protection from liability in that situation. But this safe harbor provision does not protect the ISPs from forward-looking injunctions that says that the ISP has an obligation, for example, to filter, to block, to disconnect an individual user or do something else. And it's also no protection against things like seizure or forfeiture of property, as we have seen in the DNS community, states going after the ownership of a domain name, for example, and want to seize that. And this is, of course, also a way to block access to content and so on. But it's very, from a legal point of view, and also when you discuss it from a more policy perspective, it's important to make this distinction. Liability from penal liability, claim for damages, or injunctions, right to information and forfeiture of property. That's a different issue. If we take a look at, I don't know how much you can see here, but this is Article 12. It isn't mentioned somewhere, I see. In the so-called e-commerce directive from year 2000 of the European Union. And here you find the safe harbor for mere conduit services. That is services that provide access to a communication network or transfer content from point A to point B, for example. But not, for example, services hosting content from illegal content. That is another provision, Article 14 of the e-commerce directive. And here you can see that this safe harbor, freedom from penal and claim for damages, that kind of liability is very wide. You are could not be held liable unless you, if you not initiating the communication, not select the receiver of a transmission, does not select or modify information contained in the transmission. And of course, an access provider or a DNS operator or something doesn't do anything of these kinds. So they are generally under this safe harbor. So they cannot be held liable. They cannot be sent to prison, for example, for what the users have done. And one very important distinction here, when you look at the differences between the liability for these kind of mere conduit providers and the hosting providers, is that the knowledge about the illegal activity is not mentioned here as a criteria for the safe harbor. And that was one of the issues in this case, as I mentioned in the beginning, the so-called McFadden decision from the European Court of Justice, issued just a month ago or something like that. This case was about the Court of Justice answers questions from national courts. They could ask questions on how to interpret European law to this highest court of the European Union. And in this case, it was a German court asking questions on about the liability for the provider of an open Wi-Fi, and also the possibility to issue injunctions, the court to decide for the future what this provider of an open Wi-Fi should do to stop an ongoing infringement. And one question that was referred to the European Court of Justice is it a requirement that the provider of this kind of mere conduit service, providing access to the internet, for example, does it matter if they know that they are aiding and abetting a specific infringement in a specific case? If they have been notified this is an ongoing infringement, does it affect their liability? And the court answered, no, it doesn't matter. All the requirements for the safe harbor are listed here. These are the three things that you must fulfill to have this safe harbor. Knowledge isn't one of them. So here you have a clear difference when you compare to service providers that provide host content, for example Facebook or YouTube or services like that hosts content that could be illegal or infringing in some way. If they get the knowledge about something illegal going on, more specific knowledge usually required, then they have an obligation to act. Otherwise, they lose their safe harbor. But here's an important distinction. ISPs, access providers, DNS operators and so on, they don't have that obligation to act when they know. But, and that was also questions in this case, there could be injunctions issued against these kind of intermediary service providers. And an injunction is a court deciding what obligations a party has to do something for the future. And if you don't follow that injunction, then usually you have to pay a specific amount or something like that. You're not liable for what's done in the past, but you get this injunction and then you have to follow that. And of course, you also have to answer in that court case when someone sues you and asks the court to issue this kind of injunctions. You have to go to the court and put in some legal costs and so on in order to answer these demands. So there you have to put in some effort as a service provider. You cannot just be passive and do nothing, because then you have to pay probably the legal costs, and then you still have this injunction to do something about it. So you cannot say that this has nothing to do with me. So if we have a situation in Europe where the liability is very limited for ISPs, then the possibility to issue injunctions are rather far-reaching. You can argue that this is maybe a good situation because injunction isn't that bad as a liability for penal liability and aiding and abetting infringement and so on. Because then you have to make the decisions yourself. Is this illegal? Go in to look into the traffic or something in order to decide, should I let this through and so on. But if there is an injunction, then the court says to you, the court decides, is this illegal or not? And the court decides what you should do. And then you just have to follow that. So then the court has the possibility to balance these interests we talked about in the beginning. For example, effectiveness of upholding copyright against data protection, freedom of speech, freedom to conduct business, rule of law, and so on. It's in the hands of the court, and they can decide that. So of course, in one way, it's better, but still, there are concerns with these injunctions, as far as I see it, and they are getting more and more common, as you all heard about these kind of blocking injunctions and so on, and cases going on in many countries. And if you look a bit more in detail what these injunctions against ISPs could be about, what the obligation are in these injunctions. There are cases where a court says that the ISP has an obligation to disconnect an individual user. You all remember this discussion in France about 3 strikes and you're out and so on. Then there was a question on going after individual file sharers and disconnecting them from the internet. And that is maybe now a general acceptance that is not according to the proportionality test to go after and disconnect individual users from the internet altogether. But of course there could be an obligation to disconnect a service provider from the net. If you're providing internet access to the Pirate Bay, for example, then you could be obliged to disconnect that, to stop doing that. And there we have court cases in many countries saying that. And that is maybe less controversial than other types of injunctions. For example, the big trend right now, if you look in Europe, is obligation to block own users to access specific IP address or a URL or domain name. And that is going after the ISP on the receiving side. You don't issue an injunction to disconnect the service Pirate Bay. You issue an injunction for the service provider of every user, every ISP, for every access provider. Asks the court to issue an injunction that they should do something to stop their users from entering Pirate Bay or an illegal streaming site or something like that. And as you all know, then you have the problem that it's impossible by these kind of injunctions to just stop illegal activity. If you block IP address, if you block a domain name, then you block everything that's on that server, of course. And then you have the discussion again, in which situation should you have the possibility to get a blocking injunction? It's one thing if everything on a specific website right now at least is illegal, then it's kind of easy. It's not that big issue. But for one thing, content can change over time, and also in many cases, say for example YouTube, many videos on YouTube are illegal in different ways, copyright infringement, other types of crimes. But most of the contents probably is legal. Then it's, of course, wouldn't be acceptable to issue a blocking injunction for YouTube. But then you have borderline cases, of course, where to draw the line. So either it's up to the court to decide these proportionality issues in the individual case, or in some countries we have the legislator saying that these blocking injunctions should only be available if the majority of the content, for example, of a specific website is illegal. Only then it's possible to have this kind of... and there is also case law saying, for example, in Germany, that has been earlier very reluctant to issue, where courts have been reluctant to issue this kind of blocking injunctions. But later, a year ago or something, the Bundesgerichtshof, the highest court in Germany, said that probably we are obliged under EU law to have this kind of blocking injunction, but only as a last resort. If you have done everything else to contact the hosting provider or the web hotel or something, going after everything else try to prosecute the individuals and so on. But if you've done all that and you still haven't stopped the illegal content, then maybe there's possible to get this kind of blocking injunctions also in Germany. We have cases going on now in the appeals court of Sweden where right holders had asked for a blocking injunctions for ISP to block the Pirate Bay and illegal streaming site, and it's a pending case in the appeals court. The district court denied this motion for an injunction. Then we get to even more controversial injunctions. Obligation to filter content. That is, by filtering I mean looking into the traffic and finding illegal things passing in the network and try to stop them. Many times you can of course not do that if it's encrypted traffic or if you're using a VPN service or something like that. But sometimes you can do this, but is it reasonable when you talk about these competing interests that we talked about? Here the European Court of Justice has, for a couple of years ago, said that this kind of filtering injunction is not possible to issue. It's not balanced. It would be an infringement of privacy to go in to look to every individual users, what they are sharing and copying and so on, and to look for illegal content. It would also be against a specific article in the e-commerce directive saying that member states are not allowed to give ISPs a general obligation to monitor the service looking for infringement. So it would be against that provision also, and also against rules on freedom of speech, because the court said it would always be, it's hard to say in which situations an individual user has the right to share a copyright protected work. Many times, if Peter here is my friend, if I send him, I have, according to the rules on private copy, I can send him a file that is protected. If I upload it to the net, if I send it to a large group of people that are not my friend, it's an illegal activity. But of course, it's not possible for an ISP or a filtering system to distinguish these cases. So it would probably stop also legal sharing, and that is not acceptable from a freedom of speech perspective. In this McFadden case, as I mentioned earlier, this new case about open Wi-Fi connection in Germany, the national German court asked, is it possible to ask for an obligation for a Wi-Fi provider to not to password protect their Wi-Fi connection? And the court said it looked to different types of injunctions that could be issued trying to stop illegal activity ongoing on an open Wi-Fi hotspot. And they said it's not possible to have some other types of injunction, but they said that it could be possible to issue an injunction that you have an obligation to password protect your Wi-Fi connection, and also to have the users that want the password to identify themselves. The court said it would be acceptable according to this proportionality test. But a curious thing about this judgment is that the court doesn't mention the balance with privacy or data protection. If you ask the user for their identity in order to get the password, then you have, of course, a privacy problem. And the court doesn't also mention should you have an obligation to then connect this individual who share their identity with individual activity on this hotspot. Then of course it would be like a data retention obligation to store data on what the individual user that got this password really were doing with the connection. And that would be very far-reaching from a privacy perspective. And this is the same court that, as you know, invalidated the Data Retention Directive a couple of years ago, saying that this would be too far-reaching, it's an invasion of privacy to have this data retention obligation, as it looked like in the Data Retention Directive. So maybe there is something wrong with this McFadden case, that they haven't really thought it through when it comes to this identity thing. Or maybe they just mean you can have an obligation to show your identity to get the password, but there is no obligation to store that identity or to connect that identity to individual behavior on the hotspot. But the situation seems to be now in the European Union then that there is a possibility for right holders to go to a court and ask for injunction for example, notorious hotspots that is used for infringement, that they should password protect their hotspot instead of having it completely open. And of course, this is a policy issue that is very important, of course. Many people argue that there should be more open Wi-Fi networks and so on. And then you have this problem if you face the risk of being sued and then have finally an injunction issue that you have to password protect an open Wi-Fi, then that goes completely in another direction than the policy to create more open Wi-Fis and so on. So it's something also must be discussed politically. It's not just a thing that could be left to the court trying to balance these different fundamental rights. I think that at least. And then you have also injunctions dealing with information about their users. And then we have the discussion about the right to information in the Sanctions Directive or the IPRED Directive. That was discussed very much, at least here in Sweden in 2009. There is an obligation in many countries for ISPs, if they have information about individual users, if they still store it, they have an obligation to, they could be handed in an injunction by the court to turn that data about their users over to right holders, for example. Of course, it could be turned to the police if the police are investigating a crime. But it could also be handed over to right holders when they investigate a copyright infringement or something like that. Some countries have this kind of legislation. Other countries don't have that kind of legislation. And I see a connection here from a policy perspective. And maybe we can discuss that together. I think that it's hard for the ISPs to both say, we are not responsible, we have no obligation to monitor or store information about our users, we have no obligation to turn over the identity of the actual infringer, but still it shouldn't be possible to do something about our behavior. So I think there is a connection here between the possibility to identify the actual infringer and the pressure put on the ISPs. Because is it easy to find the individual person, easier at least, to find the individual person committing a crime and holding that person responsible? Then you can ease the pressures on the service providers. But if it's impossible many times to find the actual infringer, the actual person committing a crime, then the pressure probably will be held on the ISPs to do something. You can at least you can discuss that, and you can still demand that these injunctions, for example, balance these different types of interests, that you don't go too far with these injunctions, but there will always be a pressures on the intermediaries in those situations. basically, this is what I wanted to talk to you about, and I'm interested to hear your comments or questions or reflections. Yeah.
One from a technical person. Some of the injunctions, like the obligation to filter by name, IP address, URL, can be difficult to implement if your network is not architectured this way. For instance, if you receive an injunction to block by URL, and if you have no DPI system, no proxy, no nothing, just ordinary routers, it can be very difficult. When you said that this injunction have to be reasonable, does it mean that these sort of technical constraints are taken into account by the courts or not?
Yeah, I think that the courts are looking very carefully into what is reasonable to ask the service provider to do. You must make a distinction. In some countries, the injunctions could be either open injunctions, saying that this ISP has an obligation to do what it can to stop, for example, traffic to a specific website, not specifying what to do in more detail. Then it's on the ISP's risk to do what is reasonable, in itself balancing these interests. And if it doesn't do it in the correct way, it could have these fines in a later process. So this is kind of a bit risky for the ISP, but you have this open, and then this open obligation to, for example, to do something about an infringement. But then you can say, then it's a defense that this is very hard in my system to do something other than this, and I have done this, and this is the only reasonable thing. Then you have to argue. In some countries, like in Sweden, in the UK, for example, the court decides more in detail what you're obliged to do. It says block these kind of IP address or what do you call it if you when someone put in a domain name, resend that request to a specific blocking page or something like that. And then in order to issue that kind of injunction, the court must ask the parties what is reasonable to demand, what is possible according to the system in actual use in the case. So then in that case, that would be tried. Is it possible or not? Or is it reasonable or not to ask for these specific measures? And then we have a kind of creepy connection between many countries have these systems trying to stop child pornography, created and used often voluntary in the sense that it's a pressure from the government. If you don't do anything on your own, then we will put up a law that asks you to have this kind of child pornography filter. And what we have seen in many court cases all over Europe is that the right holders said, okay, but you already have this kind of child pornography filter. What we are asking is just use that for this new, put in these IP addresses or these domain names also in the same system. And then it's hard for the ISPs to say that's impossible or it's very costly or something. They already have that kind of system. So there's a connection. That's basically what some people are talking about, a slippery slope problem when it comes to filtering and blocking. I don't know if this is the full answer, but try to answer it.
So could it be, let me rephrase it in another way. If I understand, if I buy only network equipment without any DPI functions, with just we can just pass packets and nothing more, does it mean that I have a better chance to evade an injunction or not?
It's hard for me to answer any better, but a court could not ask you to do anything that is impossible or unreasonable. So it's basically that question you have to decide. Either if you have these specific injunctions where the court decides, then the court must make up its mind on what is reasonable depending on what infrastructure you have, or what is reasonable to ask you to buy or something, but you cannot ask too much there probably. If you have these open injunctions, then it's up to yourself to do that kind of make that judgment. So as I said, it's a hard situation for the ISP to really know what they are obliged to do. Can we send back the mic here?
I have a question about the takedown requests from not from the European Union. So if a hosting company here in Sweden or in the EU take a takedown request from a court outside the EU, obviously they have the right to refuse because it's not the same jurisdiction, right?
Yeah.
That's correct.
Usually, yeah. It could be questions if it's from outside the EU.
Yes.
Yeah, they should probably refuse it. But of course, a request sent to a hosting provider could also be this kind of notice. You're aware of something illegal activity, then you lose your safe harbor provision. So that the effect of that could also be that the service provider itself says that, okay, maybe I have a liability also under Swedish law here, so I must do something about it. But there is no direct effect of foreign injunctions, of course. No.
All right. Thank you.
Thank you. I was waiting for you.
So a practical recommendation to ISPs is that you have been talking about injunctions that are sort of coming from the decisions made by court, right? That's in general what you talked about.
Mostly, yeah.
Yeah, exactly. So all of these letters that we receive from various parties that run really bad scripts and generate these automatic messages and say, oh, hereby we ask you to do these kind of takedown things. Yeah. What you are saying is that, which is also sort of, for example, what lawyers are recommending us, is that we at Netnod would just say that, I'm sorry, we have no ability, like you say, explain in the response, we have no ability to do this, blah, 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 see you in court.
If it's not something that you host, but
Exactly.
You're only a mere conduit provider, then you can do that. At least in Sweden, at least in Europe, in the US, according to their safe harbor provision in the so-called DMCA, as a Digital Copyright Millennium Act, there is an obligation for also access providers to have some kind of function dealing with repeat infringers. They must have some kind of policy and doing something about that. That is generally looked upon as a more formal requirement and so on. But now there is an ongoing case in US where ISP has been sued for individual users' file sharing. Of course, they claim we are under this safe harbor. Then the right holder says, but you have no repeat infringer policy. And that has been looked upon earlier as such, okay, it's more a formal requirement that everyone has it, but they haven't really used it and so on. So there you can have a problem. We don't know how that case turns out and what it means to have that kind of policy. But in the European legislation, the e-commerce directive, then there is no requirement to have this kind of repeat infringer policy. So then you can be more passive in that situation. You can basically file these letters in the litter bin if you want to do that. Okay, thanks then.